No conversation about financial management would be complete without talking about credit and debt. So we're going to take a look at the credit players, the tools, the scoring methodologies, as well as the debts which report on those credit reports and for how long. We'll also take a look at some of the credit laws which have certainly changed the public's interaction with creditors. So first and foremost, credit reporting agencies. They are the actual entities which gather information from the three bureaus and provide it in a format that's easy to read. The three bureaus or repositories are Equifax, Experian, and TransUnion. When you see the scoring on the credit report, you'll notice that they may have different names, such as Equifax with Beacon, Experian Fair Isaac, TransUnion, and Empirica. You may often hear of the terms hard inquiry versus a soft inquiry. What does that mean? Well, essentially, a hard inquiry is when a creditor is looking into your credit in order to make a lending decision, such as you're looking to obtain a loan, you're looking to obtain a credit card or a mortgage, and you yourself will need to authorize their inquiry into your credit report. Now, your credit score may be lowered by a few points, but if you are looking for a home or if you're looking for a credit card, usually it doesn't affect you too bad because creditors understand that you're seeking out that mortgage or that credit card or that loan. And that inquiry should stay on your report for a minimum of 2 years. Where a soft inquiry occurs when a person or a company checks your credit report in a background check. So potentially an employer you're looking to be hired by, or you're pre-approved for a credit card offer, or even if you want to check your own score. So this can occur without your permission, and it may be on your credit report, but it doesn't really affect your score. Now, per HUD, agencies may be reimbursed from clients for the direct cost of obtaining credit reports if this does not cause them a hardship. In cases where the agency receives a discount for those credit reports, that discount also must be passed on to the client. So what makes up a credit score? Well, as you can see by this pie chart here, there's different things that make up that score, such as 35% goes to payment history, 30% in the amounts owed, and for the length of credit history, 15%, new credit, 10%, and the types of credit used, meaning whether it's an installment loan, a revolving account, a mortgage, that represents 10%. So together combined, that makes up 100% of your credit score. As we look at scores, they range from very, very low to very, very high. And on this chart right here, you can see that 580 is a very poor score. Now, you may recall that in this realm of FICO scores, we have seen the exotic financing, the subprime market, so to speak. So we've seen that scores in that range generally look at that type of financing. As we graduate up the scale, 620 and 680, generally we're the range of FHA. So if you're looking for a mortgage, 620 to 680 would be acceptable. However, a lot of lenders today now are requiring at least a 680 score even for FHA. As we move up the scale here, 720 to 800, we see the good and excellent range, which is where basically the sky's the limit for you. Whatever type of program you'd like, at the very best rates are offered to you because your credit score is very high, and it shows us that you have maintained your accounts and honored them appropriately. And so lenders don't feel that that's a high risk to lend to you again. So a credit score is basically a 3-digit number. It can range from 280 to 850, and the calculation is quite complex, if you will. The creditors, or the bureaus, I should say, use a complicated algorithm which actually calculates that. No one seems to know exactly how that algorithm works, but it is simply a numeric expression of your credit worthiness. So the higher the score, the better and the more options available to you. The lower the score, the least amount of options available to you, and certainly your rate will go up because you are a higher risk to that creditor. Now, although the three credit reporting bureaus use similar methods to determine a credit score, their formulas are not exactly the same, so from bureau to bureau they will change. How long does information stay in a credit report? Well, generally the Consumer Reporting Agency must automatically delete any adverse credit instances that are more than 7 years old. And that includes collections, charge-offs, judgments, liens, and paid tax liens and student loans. Chapter 7 bankruptcies that have been discharged can remain on your credit report for 10 years from the date of filing. Chapter 13 bankruptcies, as long as they've been discharged, can remain for 7 years from the filing date. What other information is on a credit report? Well, there's generally 4 types of information you're going to see. You're going to see identifying information, which means we're going to see your name, including any suffixes, nicknames, current and previous addresses, your social security number, your year of birth, current and previous employers, and if applicable, your spouse's name. The credit that you have, who are the banks, retailers, credit card issuers, and other lenders that have extended credit to you. The accounts listed are the types of loans given to you, as I was stating before: mortgage, student loan, revolving debt, installment loans, which would be a student loan or a car loan. And the date it was opened, the credit limit, the loan amount that was extended to you, and if you have any cosigners, and how you've paid over the past 2 years. We'll also see any public records, so the state and county court records on bankruptcy, tax liens, or monetary judgments, and inquiries. So that's, again, the names of those who have obtained copies of that credit report within the last 6 months. What is the main difference between an installment loan and a revolving loan? Well, an installment loan is essentially fixed on a monthly basis. So you have an established amount that you've borrowed, let's say it's $10,000, and you have spread that over a 5-year term, and there is a specific dollar amount that you will pay every month until that term is fulfilled. There are also 2 types of installment loans. There's secured versus unsecured. So in the example I just gave, let's say it's a car loan, the car is a form of secured loans. So the car itself is the collateral. So if you don't pay your car bill, then they will come take your car. But an unsecured loan is based on your credit profile, maybe extended by your credit union or your bank, that says you have such a great credit file that we're going to extend monies to you without having any collateral. So they're secured and unsecured. Where a revolving loan basically is an open-ended loan. So that if $10,000 was your credit limit and you went out and spent $500 tomorrow, and then at the end of the month you paid that $500 back, you would still have $10,000 that you could borrow. So it will vary based on what you spend and how much you pay back. And another example of that we see is the form of a HELOC, which is a home equity line of credit, when it comes to owning a home. Now, there is such a term as non-traditional credit, which essentially means that if we don't see enough credit lines on your credit report, there are ways that lenders can put together a non-traditional credit report for you. So they use anything that you have paid on faithfully but just doesn't report to the bureaus. That can be any loans, utility bills, rental payments, insurance, payment to health care providers, and so on. If it doesn't report to the bureaus and you can prove by way of either bank statements or canceled checks that you've paid consistently, that's what lenders will use to put together a credit profile for you or for your client. Now, there are plenty of laws that have come about due to either deception or slick marketing campaigns and slogans that the vendors or creditors have utilized with the public. So we're going to take a look at some of those. And the first one here is the Fair Debt Collection Practices Act of 1977. Basically, the nation's Consumer Protection Agency, the FTC, enforces this act. And it prohibits debt collectors from using abusive, unfair, or deceptive practices to collect from a consumer. Imagine that. What creditor practices are off limits under the FDCPA? Well, if you turn to the chart on page 32 of your manual, you will see that they are not allowed to threaten, use obscene language, use false claims, provide false information or documents, threaten arrest, or charge extra fees which are not warranted to the client. So believe it or not, at some point this was going on. Which federal benefits are exempt from garnishment? Well, if you look at page 33 in your manual, you'll see that you cannot, or creditors cannot, garnish Social Security, veterans benefits, service members pay, student assistance, merchant seaman wages, foreign service retirement and disability, and FEMA assistance. Then we have the Credit Card Responsibility and Disclosure Act of 2009. This act had a sweeping effect on the consumers in the areas of annual percentage rates, fees, and disclosures. And on this next slide here, you can see a slew of bullet points that refer to what creditors may or may not do. So for instance, number 1, it limits the card issuer's ability to increase the APR on transferred balances during that first year. Another one states that the teaser rates must stay in effect for at least 6 months, or the disclosures must be made clear and more timely. And so it goes. And again, that's because we had a lot of clients in confusion, misunderstood terms and arrangements, and it was all to their own detriment. So this law was put into effect in order to protect the consumer. The Consumer Credit Protection Act of 1969 is an umbrella consumer protection law that includes the Equal Credit Opportunity Act, the Fair Credit Billing Act, the Fair Credit Reporting Act, and the Truth in Lending Act. So let's look at each one of those. The Equal Credit Opportunity Act of 1974 basically states that any discrimination in credit transactions on the basis of personal characteristics such as their race, their color, their religion, their sex, their national origin, marital status, and so on is absolutely not allowed. The only acceptable criteria for receiving credit is the ability and the intent to repay the funds that are borrowed. The Fair Credit Billing Act of 1974 requires that a credit card company promptly credits your payment and corrects any mistakes on a bill without costing you damage to your score. It also permits billing errors on your credit card to be disputed and withholding payments for damaged goods. So essentially here, consumers can certainly notify the creditor in writing. I would also pick up the phone, but notifying in writing has a paper trail to it, so you can see what the requirements are there. The Fair Credit and Charge Card Disclosure Act of 1988 requires that a lender offering a credit card to disclose certain terms on that card, including the APR, the amount of any annual fee which is due, and whether you have an interest-free period to pay your bill before any interest charges are added. You'll probably also remember that our commercials went from not having any of that information in small agate type at the bottom of the commercial to having those. That's a requirement because it has to be disclosed if you're offering a payment or any kind of terms, how you got to that payment and those terms. So you'll notice that on some of our financial commercials that we have on TV today. The Fair Credit Reporting Act, or FCRA 1970, protects against inaccurate or misleading information in credit files maintained by those credit reporting agencies. So it requires that individuals know what is in their credit file, and then they have the ability and the power to actually correct any errors. Now, according to that act, when we are talking about issuing credit reports, credit bureaus, the most common type of those are the agencies that compile those reports, are required to help clients understand that report. And so reports can only be issued to those who have a legitimate business. Now, what does that mean? A legitimate business is a lender or a creditor that is calling upon that report as a tool to figure out whether or not they'd like to do business with your client. So that's why you would hear that you're not entitled necessarily to a credit report from the creditor you're working with unless you were turned down. And then you can't get it from the creditor. You need to actually go to the bureau and request one and show them that, or the agency, and show them that you are requiring one because you were turned down. So it's a little distinguishment there, but certainly it's necessary to understand why they've distinguished it as such. Now, any errors, the Bureau is responsible for investigating and for changing or removing any incorrect data. And then the source of that error must then notify all consumer reporting agencies. Now, the client does have a right to also add their own clarifying statement if they like. But there was recently a show on that talked about the fact that the bureaus have been somewhat slow with their response in correcting any erroneous data, and that oftentimes folks are having to get legal counsel involved just to expedite that process. So it is something to be aware of. They certainly serve thousands, if not millions, of people when it comes to that information, so they move a little bit slowly. So you want to make sure that if your client is challenging anything, they let all three bureaus know, and that they also do it in writing, and if need be, they may need to get legal counsel involved if it's serious enough. Now, with respect to denied credit, if a credit application is turned down because of an error on that report, again, the lender is required, as I was saying before, to provide the name and address of the credit bureau that issued it. And then that client can get that for free, that credit report for free, so that they can understand what exactly is affecting the ruling from the lenders to turn them down. And disclosures. Consumer reporting agencies must provide access to the information in the credit report, as well as identify who have requested the information recently. There's usually a charge for that report unless that credit has been recently denied. Consumers are entitled to one free report a year, and they can ask for that in writing if they are unemployed and plan to look for a job within 60 days, or they are on welfare, or the report is inaccurate due to fraud. Now, you can also obtain a free credit report from annualcreditreport.com. However, they will not provide you the credit scoring from the bureaus, so you'll just have the credit report itself. But that's another choice. Now, limiting access. Clients may request that consumer reporting agencies not distribute their name on lists used by creditors and insurers to make unsolicited offers. So when we talk about those pre-approved offers that come to your home in the mail, that's what this is referencing here. So you can have your name removed from the list so that you don't get those types of offers in the mail. And trust me, they can be quite a few of them coming to you. I have quite a few myself that come through the mail all the time, and I recommend, if you're not going to take advantage of them, that you do shred those applications so that nobody else can also utilize that form or steal your identity. Consumers have the right to sue consumer reporting agencies, users, and providers in state and federal court for any violations of the Fair Credit Reporting Act. And we would expect nothing less, especially today in our litigious society, but also because if there are violations, we want to make sure that that gets taken care of immediately. Now, bankruptcy. There are two types, Chapter 7 and Chapter 13. One's a liquidation, one is a reorganization. So let's look at each one. So in a Chapter 7, essentially, the client says, I'm unable to pay anybody anything more. What will happen is their assets are sold and that money is divided among their creditors, so whatever is able to be gathered together is able to pay some of these creditors off. So certainly some things they're able to keep, such as their car, maybe personal property, perhaps a home. Some debts, however, will absolutely not go away. And those are child support, student loans, taxes, and alimony. Chapter 7, as we said before, can stay on your credit report for up to 10 years. So typically in lending, this is looked upon less favorably than the next one here, which is the Chapter 13 reorganization. The Chapter 13 reorganization says, okay, I'm having trouble paying back everybody, but I want to honor as best I can payments back to the creditors. So what happens in that situation is a plan is made to pay them back. The individual makes installment payments to the court. There's a trustee that's in charge of that, and usually that reorganization takes anywhere from 3 to 5 years to complete. So the creditors then also have to agree to accept less than the full amount that they were owed, and as long as our individuals make on-time payments, they get to keep their assets. The Chapter 13 will stay on your record for at least 7 years. So this has usually been looked upon by lenders and creditors more favorably because the client is looking to at least honor their debt obligations as best as they can. And finally, counseling and education requirements are still there when it comes to filing bankruptcy. So consumers have to file a certificate of completion of credit counseling courses when they file for bankruptcy. So that is really important. They have to do that. Only credit counseling organizations and debtor education course providers that have been approved by the U.S. Trustee Program can even offer those certificates of completion. And credit counseling must take place before filing for bankruptcy. And there's a debtor education that must take place after filing. So what we see here with even filing for bankruptcy, the before and aftermath, education is still going to be important and even necessary when we're dealing with debt